There are big developments in the Adani Hindenburg case that is being heard in the Supreme Court. The Security and Exchange Regulatory Authority has told the Supreme Court that it has closed 22 of the 24 cases it was probing into the Adani Hindenburg case. The Supreme Court has now refused to accept the Hindenburg report for lack of finding its veracity. SEBI has also raised serious questions on the transparency of the Organized Crime and Corruption Reporting Project, which is an NGO which refused to provide details when sought by SEBI. Now, it's also interesting to note that this NGO had earlier prepared a report on Adani short selling and shared it with SEBI. It had alleged that the opaque Mauritius funds were used to funnel substantial investments into the publicly traded stocks of the Adani Group, giving us and encapsulating what happened in the Supreme Court and the statements that were made by SEBI to the Supreme Court. Joining me on the telecast is my editor-in-chief, Rishabh Gulati.
Okay, Megha, thanks a lot. Let's now look at the bottom lines. What are the takeaways of this marathon practice that has gone on now for several months? Remember, we're talking about the period between May to July, at the first time that the expert committee report presented itself to the Supreme Court. The expert committee report found no illegalities or a breach of disclosure guidelines by any of the Adani Group entities. They did, however, make recommendations for future best practices. So what has happened in court as we speak? Number one, the Securities Exchange Bureau of India, the SEBI, has come out and said that 22 out of the 24 lines of investigation that they were concurrently doing into various Adani Group entities have been closed, which means the majority of the probe is now concluded. They have made no fresh allegations before the Supreme Court on any of these line of investigations. So the SEBI has all but concluded its investigations, for which it had sought more time from the Supreme Court. The last time when the expert committee report was submitted before the Supreme Court, they said it's a complex financial matter involving international transactions. We require more time. They've had the time. They've now come and told the Supreme Court, we don't require an extension. They have concluded the majority of their investigations, and they are making no fresh allegations against any of the Adani Group entities. Within the context of this, major developments have taken place, and let's put them out one by one. Number one, the Supreme Court has warned Prashant Bhushan, who showed up in court to argue, that he should not cast aspersions on the members of the Supreme Court appointed expert committee. Prashant Bhushan had been claiming that one of the members had been a legal representative of the Adanis in 2006. And the Solicitor General has pointed out and said that if you represent one company, by this logic, nobody will be able to become a judge in the country, because a lot of the judges are former lawyers and they've represented various companies. So the Supreme Court has made it very clear on the issue of the expert committee having a conflict of interest. That chapter is closed. The second attempt by Prashant Bhushan to include the Hindenburg report as part of the proceeding of the Supreme Court has been cut off. The Supreme Court, and this is a bench which is being led by the Chief Justice of India, has told Prashant Bhushan that there is no way to identify the truth in the claims made by the Hindenburg report. This means, the court says, we can't verify the contents. There is no way for us to verify the contents. We are not saying whether it is accurate or inaccurate, true lies. We are saying that since there is no way to prove the veracity of the report, therefore it cannot be admitted before this court or read out as proof within this court of some sort of malpractice. So the Supreme Court has thrown out attempts by Prashant Bhushan to incorporate the Hindenburg report as some de facto evidence in these proceedings. They've also pointed out, as the Solicitor General has pointed out, that one of the NGOs which had claimed some 3,000 crore transaction via Singapore, via here, which was based out of Chennai, that Prashant Bhushan was using that NGO report. The Solicitor General has said that the NGO report to which Prashant Bhushan is alluding is an NGO in whose running he himself is involved in. So there's a major conflict of interest in the publication of that report as well. Now, on the larger scheme, the Supreme Court has come out and questioned the SEBI on the matter of short selling. The question now is, was there a syndicate, was there a cabal operating that undertook an ambush, a hit job on India's stock markets? We've seen a lot of incendiary Freudian slips coming from George Soros and others. Was there an attempt to bring down the stock to have profit-making initiatives from Hindenburg, which we know made money out of this? How much we don't know, but we know they made some money. Who all made the money? Now, the expert committee report had pointed out suspicious transactions. So the Supreme Court has asked the SEBI what it will be doing, and the SEBI has come and said that it will be investigating this in concurrence with existing rules and regulations. When asked whether those existing rules and regulations require to be amended, they have said prima facie no, but they have not raised any objections to the expert committee recommendation. Now, the expert committee recommendations made generic recommendations regarding future transparency on what is the concept of the ultimate beneficial owner, which means if there is a firm owning shares in a firm owning shares in a firm owning shares in a firm, who is the ultimate beneficial owner? The Supreme Court expert committee had made generic non-Adani specific recommendations, and the SEBI has come out and said it is the prerogative of the central government to amend these rules. They are not taking a position against any of the recommendations. They will consider all the recommendations and examine them. So what's the bottom line? The bottom line is that this was the last bit of the puzzle after the expert committee report basically exonerated the Adani Group entities of any malified practice against or in violation of existing rules and laws. So the expert committee found nothing. The SEBI investigation was going on parallelly. The expert committee made generic recommendations. The SEBI had asked for more time. They now say we are almost done, we require no more time. And they have not made any fresh charges. So as far as the existing matters against the Adani Group are concerned, the chapter in the Supreme Court is being closed as we speak. As far as the attempts of Prashant Bhushan to introduce the Hindenburg report as some sort of bona fide document of proof in the courts has been dismissed. And the efforts by Prashant Bhushan to question the veracity, potential conflicts of interest of the Supreme Court appointed expert committee, not a government or Adani appointed expert committee, the Supreme Court appointed expert committee, he has been warned against casting aspersions on any of the Supreme Court expert committee members. Megha.
Okay, all right. That's interesting. A good analysis and synopsis of what has happened in the Supreme Court, what are the ramifications as well as the impact that will have on the stock market as well as on the Adani Group of companies. Sharat Kohli, quickly getting into the conversation here. Now, it looks like the case is nearing its end. Is it a likelihood that the Adani Group of companies is going to be absolved of all the charges, all the allegations that have been made, whether it is the Hindenburg report or for that matter, the NGO that has come out making charges, said there is opacity in terms of the funneling of funds of the Adani Group of companies, the shell companies that had been set up in Mauritius?
Thank you, Megha. From what I could make out of the observations and what transpired in Supreme Court and Rishabh's analysis, well, I am of the opinion that if I want to conclude this in one sentence, I would say nothing material has been found, because the case, as per me, was based on conjectures and surmises, as it is called. The technical term used in court is conjectures and surmises. You were assuming something, that because there were shell companies, so money must have been sent there, that money must have been brought here. You see, these are the things. If we understand stock markets properly, short selling is a process by which, through the derivative section of stock markets, you short sell. Now, short selling in FIIs, every evening when the stock market closes, I'll tell you from where this observation is coming from. Every evening at 3:30, when the stock markets close, a data comes out in the evening. Now, this data looks like this: cash selling by FIIs, cash buying by FIIs, cash selling by FIIs in futures and options, cash buying by FIIs in futures and options. So basically, when it comes to short selling, this is an everyday process. Now, to be pinpointing on a particular group, well, yes, there was short selling done. There was no doubt about that. But what kind of money was that? And who ultimately made money? We all know that. I think we've discussed this umpteen number of times. that there was an agenda to hit India's infrastructure. I don't want to name Adani's, Adani as a person being the richest at that time, came down the ladder to being number 30 or 25. That doesn't matter. But the target was to tarnish the image of India where it is heading towards being a developed country by way of targeting the infrastructure. So anybody who's involved in infrastructure, just go and target that, bring down the valuation, bring down the reputation. So I think the agenda was very clear.
Okay.
Now all we can make out, Megha, is from the agenda that this was, rest of it is based on conjectures and surmises, because we cannot conclude. Supreme Court by itself has said that veracity of the facts or veracity of the case cannot be fully concluded upon. So I mean the matter Supreme Court by itself, without giving a judgment, has sort of very clearly stated.
Okay.
That whatever has been put on record. Yes, Megha.
Okay. Dr. Jayajit Bhattacharya also on the show with me. Dr. Bhattacharya, now with the conclusion, now with the hearing coming to an end, what is the next step that the Adani group of companies, can SEBI take the next step in questioning the Hindenburg report or this NGO that came up with the report? What is going to be the next course of action for Adani Group? Is SEBI then going to be involved in this? Does it have the jurisdiction to get involved in this?
Well, that's a good question. Does it really have the jurisdiction? Because some of these companies are not listed. In fact, the interesting point is that some of these were startups, such as Adani Total Gas. And therefore, its PE ratio was extremely high, just like any startup, because the revenue is near to zero. The valuation comes from what is the potential and the market size, and that's how the valuation comes in. So these were kind of taken out of context and touted that there is a disproportionate PE ratio, whereas the stable businesses such as ports and so on had regular market valuation, regular PE ratios, and therefore the SEBI jurisdiction is restricted to those companies which are listed in the stock exchange. If they are not listed, if they are being traded privately, then that's not a jurisdiction that SEBI comes into. It's only when there is public involved in a public market, stock market, that SEBI steps in. When shares are traded privately, the trading partners are supposed and expected to have sufficient information about the stocks, about the business, and will be taking steps as per their own knowledge about the matter. But when it's a public that's involved, they can always be taken for a ride, which is where we have institutions such as SEBI, RBI, and so on and so forth to take care of the public interest. The allegation largely is that Adani had manipulated its stock prices to an extent that the public were quote unquote fooled by it, and therefore the final allegation being that Adani fooled people to get money in and to invest into their stocks. I think we might even come out with an outcome that SEBI says that there is nothing to say that that's true, or it may find a whole bunch of issues with Adani, with the listed companies. And that's where SEBI will take it forward, obviously,
okay,
but also still lie in the courts of the Indian judicial system.
Okay, all right. Quickly getting back to Rishabh over here. Now, how does India, the government of India, take this forward? Because not only has millions of shareholders who've lost their money, this is tarnishing the credibility, loss of face for the Adani group of companies, and bringing an attempt to deliberately bring down the economy of the country, markets of the country.
Okay, there are three or four things, okay, which we have to be damn sight clear about, okay. What the Adani group does to restore confidence and stability in their own shareholders, in their own balance sheets, what they do to sue Hindenburg in various courts across the globe, maybe perhaps even here, that is for them to make a decision on. They've taken several steps already to stabilize their share prices. What's the bottom line? The bottom line is, does India have regulatory agencies and regulatory practices? Do we have the SEBI? Do we have the DRI? Do we have the Enforcement Directorate? Do we have the RBI? And do we have our courts and other government functionaries? If we have regulatory practices, how does what Khet ki Mooli becomes then Hindenburg? How is an agency sitting in the United States becoming the fulcrum of investigations against a large Indian entity? It's a fundamental question. Now, you've had an expert committee appointed by the Supreme Court of India, the best people who know the practices. We've read out all the names of the expert committee, people who've been involved in this for decades. They have prima facie found nothing. The SEBI has been investigating various angles since before the Hindenburg report also. They've come out and found prima facie nothing. The expert committee has made generic recommendations on how we can improve transparency, etc., but that's a generic, it's not Adani specific. In the context of all of this, as we speak, the other issue of trying to, destabilize, not the Adani group, remember, LIC, SBI, there was an effort to destabilize these major entities, India's largest bank, India's largest insurance agency, one of India's largest conglomerates, and we saw the Freudian slip from George Soros. We've seen so much political tamasha over this. You know what's happened in the Mahua Moitra case that has come out in Parliament recently also. So the other fundamental question is, was there a cabal operating that, number one, saw a confluence of interests? Confluence of interest is that for a certain sector of the cabal, they are making billions. So it's clear money. Money matters to them. George Soros, who described himself as the god of humankind, who is let's face it, there is some mental imbalance over there. He has said very clearly that the government of India has to be accountable for what's happening in Adani. So is there a secondary cabal operating where profit motive, which is an understandable motive in any kind of hit job, okay? But was there a secondary motive to disparage India's image, the credibility of India's regulatory agencies, the credibility of India's jurisprudence system, and India's political system and governance? These are very, very strong questions. So today, Adani Group walks away exonerated prima facie of any of the charges, which means that India's regulatory bodies and investigative agencies can't find them in violation of any existing rules. They did the disclosures, they published them, they've come out with the multiple point defense that we made everything public when it was required to be public of who's buying what. Now in this scenario, Megha, it is only but obvious that for the people who were the shareholders of the Adani stocks at that point of time, who had to face the brunt of the ambush, maybe even lost money to somebody else's profit, how do we ensure that they are brought to justice, that an exposure is done on how much money Hindenburg made, how many billions they made, the dubious short selling transactions that were highlighted, and we don't know if those were the only ones, there might be others, in the expert committee report, who will investigate them, and now who will hold this cabal accountable? In the end, when you walk away and the dust settles, there has to be accountability. All these people were seeking accountability from the Adanis. Now you've said that the accountability has to sort from them, from Hindenburg, from George Soros, from the international cabal, from potential collaborators within political dumb over here. These are very serious things, because making a charge against someone, you're welcome to make it. But impacting the stock market to the tunes of billions of dollars, the fact that the India stock market was resilient and did not collapse is a separate issue. That's a factor of our growing economic strength. But to target a major conglomerate, then target SBI, then target LIC, and even those matters have been thrown out by the Supreme Court. They say there's no reason to probe LIC investments and SBI investments because there is no proof. There's no wrongdoing that is being alleged here. So what are these random people coming and demanding investigations for? And you know what's happened to Prashant Bhushan in court. Okay.
Then Sharad, when we talk about accountability, those who need to be pulled up, probes that need to be initiated against them. And when we talk about George Soros, now he is a man who is reputed to have made several of these short-selling hit jobs. When we talk about the London Central Bank, that was completely devastated. There were certain of these short-selling hit jobs that he had initiated in Thailand, Singapore, but nothing came of it. So what is the guarantee that there is going to be a credible, strong probe that is going to be initiated against him and other probable potential stakeholders in this? And what is the possibility that they are going to be held accountable, they are going to be brought to book?
Well, two things, Megha, I would recommend out of your question. One is, a SEBI observation which I was reading, that the government of India has to change the rules. If that's the way the stock market operates, if short selling is legal here, as I said, a data comes in the evening where FIIs and the FPIs have to disclose their short selling numbers every evening. So the rule of the game is you are allowed to short sell, first of all. So short selling, we have to understand, first of all, is not a crime. One. So first of all, Government of India, along in consultation with Stock Exchange and SEBI, Ministry of Finance, three agencies involved, Ministry of Finance, Stock Exchange and SEBI, they have to sit down together and they have to change the rules, at least for the FII. Short selling locally can be allowed, but FII money coming into short selling, I think that has to be taken off. Of course, the proxy money will have to be accounted for as well. Second, I think after this court conclusion today, or shall I say, which seems like a conclusion as of now, I think Adani Group must move US courts and Indian courts. And I would also recommend, I don't think although that will be done, but I would also recommend Government of India and regulatory agencies which Rishabh spoke about, the RBI, the SEBI, they should move the courts in US, and not, you can't file a case because Hindenburg short sold. That cannot be the case. But the agenda and the propaganda. In fact, Rishabh said that there's a primary motive of making money and a secondary motive, which we need to expose. I would stretch Rishabh's statement and I would like to change it or tweak it a bit. Primary motive of the agenda and earning money in the bargain. For me, that is the way I perceive it. So I think an immediate lawsuit to be filed in US, a lawsuit to be filed in India, Adani Group comprehensively. And along with that, I think Government of India, SEBI and RBI and stock exchanges must parallelly file a suit where this agenda, because if we just let it be, then we'll just be victims. People lost money. I know dozens of people, Megha, who lost lakhs of rupees. These were small retail investors who lost money. Forget about the institutional investors. So I think if we cannot, make good their losses, the bare minimum we could do is hold these people accountable. Okay. The people behind Hindenburg must come forward, and we should claim a very hefty compensation, both for defamation as well as monetary, Megha.
Okay, all right. Dr. Jayajit, I'm just going to put out some figures from how the stocks were moving before these observations by the Supreme Court were made, and after these statements and these observations and arguments were put forth by SEBI and, of course, the counsel who was fighting for the petitioners. Now here, Adani Ports, which was down at 0.93%, Adani Enterprises up at 0.8%, Adani Green up 1%, Adani Wilmar at 0.29% up, Adani Power 1.91% up, there's Adani Energy Solutions 1.07 up. So besides Adani Ports at 0.93% down and Ambuja Cements, which was 0.64% down, rest all of the enterprises that belong to Adani Group of companies were moving up. And after the resumption of the courts and after these statements were made, after the observations were made, we continue to see that Adani Port was down by 0.78% and Ambuja Cements at 0.60%, which also reflects the sentiment of the markets, the sentiment of the people. It has been a certain period of time since the Hindenburg hit job happened. We obviously saw there was a drop, massive drop in stocks of Adani Group of companies. But it seems like there has been reinstatement of trust and credibility for Adani's.
True. In fact, when the Hindenburg report came up, the Adani Group ended up losing about 8 trillion rupees. And since then, they have recovered 5 trillion rupees. So without the Supreme Court judgment. I believe moving forward, there will be a further recovery in the Adani stocks. Cement obviously is a cyclic industry and is going through a downturn across entire Southeast Asia. So Adani will be no exception to that in terms of their cement company. But as you mentioned, rest of the companies are all seeing an upswing and an upswing in the prices. And that's going to happen even further because it will end up recovering all that it lost before the Hindenburg report came in. However, I would like to observe that Adani also lost 1 year of growth because it got constrained in terms of capital inflow. It got constrained in terms of being able to move ahead with its investments, which also that we lost 1 year of employment opportunities, 1 year of additional GDP growth, and so on and so forth. Those are things that nobody will compensate us for.
Right.
We recollect the 1996 Asian financial crisis. The then Prime Minister of Malaysia, Mahathir Mohamad, came out very pointedly accusing George Soros of being the mastermind of that entire collapse. And I think somebody of the stature of Mahathir Mohamad, the Prime Minister of Malaysia, saying so, we should hear that with good cognizance. And hence all the co-panelists, what they were saying about the Indian government taking this as a hit on India or warfare by other means, should therefore pick up all mechanisms possible to be able to ensure that nobody dares do it again against India or Indian companies in future.
Okay. All right. Quickly then, Sharad, coming back to you. Now, this absolves Adani Group of companies. This also tells the world in the global market that our markets regulators are credible organizations, are credible bodies. But why would questions be first of all posed? Now, when we talk about market regulators in United States or in Europe, we never question them. We take them on face value. So is it because we are a middle income nation coming in from South, coming in from global South, living in Asia, and therefore they have the prerogative of questioning us as a country, as an economy, and also then point fingers at our regulators?
Megha, first of all, we are no more, those kind of, we don't have that characteristics anymore. I mean, today, the new India, the resurgent India is much more authoritative. Today, when our external affairs minister speaks, he speaks with authority. And the kind of statement which I hear these days, they were never spoken of before. We are very forthright when it came to Russia-Ukraine war. When it came to anything, on any international diplomatic issue, we are very, very authoritative. And I don't think we are scared of anybody at the first point. Now, if you look at the questions, Megha, very quickly. The first question was that there were shell companies which were used to do round tripping, that is to bring the money back. No evidence on record. There may be companies, but if there is no evidence on record for round tripping, I think that particular allegation becomes baseless, number one. Number two, what Dr. Jayjeet mentioned, that the valuation of the company. Now, any investor who's pumping money into a company, the basics, to get the basics right, you check the PE ratio, you check the book value, you check the sectoral performance, you check the revenue, you check the promoters, you check the order book, and so on and so forth. We do a fundamental analysis of any company. Do you think anybody who was investing in Adani Group till now, well, a lot of them are institutional investors, and I might point out here that LIC and SBI has got a separate expert wing where they pick and choose companies. I have seen investments coming into highly valued companies where that is the PE ratio is very high, and I have seen zero investments coming with PE ratio being very attractive. So this is a very subjective issue. So all the allegations levied, Megha, I go back to what I said in the beginning. They are based on conjectures and surmises. Right. Okay. If this was the case, this was the case. If that was the case, that was the case. I don't think anything in law survives when it is purely based on imagination, on conjectures and surmises. Okay. I would like to reiterate, Megha, as a concluding statement, that this matter should not be allowed to go to prevent any future, reoccurrence. A legal action, comprehensive action at diplomatic level, at legal level, it should be taken without any delay.
Okay. All right. I only have as much time. I thank all of you for joining me on the telecast. Big revelations. This is going to turn the tide of what the Supreme Court hearing that has continued this now. Like I said, this is nearing the end of the journey that SEBI has taken in terms of probing the Adani Group of companies. 24 of those cases that were being probed, 22 of them have been now completely closed. There are no charges that have been now levied against the Adani Group of companies.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.